You're tuned in to Agriculture Today, and we start our Wednesday show discussing agricultural law and taxation items that people should be keeping in mind with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Thank you for having me, Shelby.
Roger, talking through a few different topics today, but first discussing digital contracts. And before we talk about the digital aspect, what are components that make a contract a contract?
Well, every contract, Shelby, has some basic core elements to it. We have to have an offer, and that offer has to be accepted, and then there has to be consideration or something of value that is exchanged between the parties. And in general, there has to be a meeting of the minds as to the essence of the contract. In other words, if you and I are negotiating over something, what you're offering, I must accept that. We can't have a misunderstanding as to what you're offering. And we get into these issues with oral conversations. You say one thing, I'm thinking another. And we didn't really have a meeting of the minds as to what the core essence of that contract was. So we got to have all of those elements to have a basic contract that would be enforceable under law.
As we're talking about contracts, remembering also that if there are changes, both parties need to agree on those.
Yeah, that's true. We used to have, years ago, before we got what's known as the Uniform Commercial Code, we used to have what's known as the Battle of the Forms. And so you would make an offer to me, I would modify it, send that back to you, you would change that, go back to me, and so we would battle over the structure of the form, the language in the form, back and forth and back and forth. So that acceptance has to mirror the offer. And so any change means no deal until the original person that offered what it was for sale accepted the new term. So that's a kind of another core element that's out there and that's basic to all contracts.
We've mentioned contracts many times with you, Roger, and wanting to remember that the digital contracts are just as binding as the paper ones.
Yeah, that's true. You have to make sure you know what you're signing, whether it's paper or digital, and you have to be, I think, particularly careful with a digital contract. If you're going to click to accept the contract's terms, make sure you know what you're accepting. I think we've all been there with respect to buying something online, and we hit click to accept, and then we realize, well, wait a minute, I just bought two of those, or I only wanted one, or no, I got the wrong shipping address, those types of things. So before you click to accept, make sure that everything is in line with the way you want it, because that acceptance, you might be able to go back and fix it. But boy, that really casts it in stone when you click to accept on a digital contract.
And another thing that producers might want to be thinking about when it comes to estate planning, a Spousal Lifetime Access Trust, and what is that?
Well, that's a good question. It's also known as a SLAT, an SLAT, Spousal Lifetime Access Trust. And this is a technique that I think is probably pretty valuable to some people right now that might have an estate tax problem if the estate tax exemption drops, which it will if Congress does nothing, starting in 2026. And what it is an irrevocable trust that is designed to provide income to a beneficiary spouse while removing the trust assets from the grantor spouse's taxable estate. Now, it is irrevocable, so you can't modify it or revoke it without great effort. You can't basically revoke this or modify it after you create it, and the assets cannot be returned to the donor spouse. And so what you do is you set up a trustee, and the trustee has to ensure that the trust assets are going to be used according to the trust terms and that the beneficiary spouse will get the income from the trust for life. And then when that spouse dies, the remaining assets in that trust pass to the designated beneficiaries that are listed in the trust free of estate tax. I think that could work well. This whole technique would work well while the exemption is high, which would allow you to shelter a lot of asset value into that trust and offset it by that high level of the exclusion amount right now. That value would also, as I indicated, be kept out of the beneficiary spouse's estate because they just have the income from the property for life. And so if you've got assets that are going to appreciate in value, then the tax benefits can even be greater in terms of getting the maximum benefit out of reducing taxes. Now, the downside on this technique is that the ultimate beneficiary, say your children, won't get a step up in basis at the time the second spouse, the beneficiary spouse, dies, because that's just life estate property. So their basis is going to tie to the value of the assets at the time they were transferred into the trust. So it could be a useful technique for people, but they do need to talk to their tax advisors and their estate planning advisors to make sure this is something that will actually work for them.
And within this blog article, another topic you covered involves, once again, the waters of the United States. And what can you tell us about this case?
Well, we've got a case out of Idaho that has taken the Sackett opinion from the Supreme Court in May of 2023 and applied what the Supreme Court said to this ranching operation in central Idaho. And what happened was that the EPA came in and claimed that the ranch had discharged pollutants into a navigable water of the United States, which was a river that went through the ranch, and associated wetlands that they said were adjacent to that river, without having a Clean Water Act discharge permit. And it was the EPA and the Corps of Engineers then that notified the ranch that they were going to start investigating potential violations of the Clean Water Act. And as it went on, the EPA ultimately sued the ranch, claiming they had made illegal discharge of pollutants by constructing multiple road crossings across the river and across the wetlands, which impeded the flow of the water and polluted the river, and that they were mining sand and gravel from the river, and that they had a center pivot irrigation system that disturbed the wetlands that they claimed were under their jurisdiction at the federal government's level. And so the EPA wanted an injunction that would shut the ranch down from further discharges and would require the ranch to restore the impacts that they had made on the river. And the ranch moved to dismiss the case, and the court granted the motion and dismissed it, saying, well, EPA, in your pleading, you didn't sufficiently specify that the wetlands at issue had a continuous surface connection with the river to be considered indistinguishable from the river, which was the test that came out of the Supreme Court Sackett opinion in 2023. The court said it's not enough, government, for you just to assert that, well, you can clear up any confusion on that point during the discovery process. And the court said, no, you have to give specific allegations at the pleading stage, and they didn't do that. And since they failed to state a claim upon which the court could grant relief, they dismissed it. But they gave the EPA a chance to amend their complaint. They had to do that within 30 days of the court's order.
What could this mean for farmers and ranchers?
Well, I think it means that the Sackett test is going to be really beneficial to farmers and ranchers and rural landowners in general. And the government just can't come in and claim that your wet area, which might be adjacent to a navigable water course, such as a river, without specifying where the river ends and the wetland begins. In other words, there has to be a continuous surface connection between the two. And that is the test. And that's going to help a lot of people in Kansas, in particular western Kansas, because there may not be a continuous surface flow of that water. There may not be a connection, a direct connection with the regulable water course, and so it's going to remove a lot of ditches that have just a non-permanent flow of water through them, intermittent flows, and kind of the Playa Lakes area around Great Bend.
On the opposite side of water, wanting to mention drought and an IRS code provision when it comes to extended livestock replacement.
Yeah, there's this rule in the code, Shelby, that says that if you have to sell more livestock than you normally do in a particular tax year because of weather-related conditions, and of course this is known as the drought sale rule, but it's all weather-related conditions. If I have to sell more than I normally would, I shouldn't have to pay tax on that additional amount, because that might change my tax planning, obviously, and it might bump me up into a higher tax bracket. So what I can do is I can defer the gain on the excess number of livestock sold attributable to that excess until I replace those and then sell the replacement animals. So it's an involuntary conversion provision. So I take the excess that I sold, I replace them with like-kind livestock. When I sell the like-kind livestock down the road, that's when I would report the gain that I've deferred from my existing herd. Well, the replacement period used to be 2 years, then it got extended to 4 years, and then IRS said that if drought continues, you get to add another year. If you haven't had a drought-free year in your county, you get to add another year to your replacement period. So that 4 goes into 5 could turn into 6, so forth and so on. And every year by the end of September, the IRS publishes a list of the so-called drought counties, and the vast majority of Kansas counties do qualify for that additional 1-year extension.
Roger, what counties in Kansas aren't qualifying for that this year?
Well, Well, it's kind of interesting because normally the counties that don't qualify are in northeast Kansas, and indeed there are 2 or 3 of those. We got Brown and Donovan and Nemaha counties that didn't get the 1-year extension, so the 4-year replacement period still applies. But then we have Cherokee in the southeast, and then we have Cheyenne, Logan, Wallace, and Wichita, which, interestingly enough, were not drought counties from the beginning of October last year to the end of September this year. So they do not get the additional 1-year extension for excess livestock sales on account of weather-related conditions in those counties.
Are all livestock included in this code?
Well, no. They have to be held for draft dairy or breeding purposes, and poultry do not count also.
Roger, I appreciate you taking the time to join us today.
Thank you very much, Shelby.
That was K-State and Washburn law professor Roger McEowen. I will link his blog articles where he talked about these topics in today's show notes on agtoday.net.